contrast, isn't it,
So,
between the options which are open to the workers and their unions by way of using and enforcing the law, and the options that are open to employers on the other side. So if an employer is faced with a strike which is in breach of the law, the employer can go for an injunction to stop it. And if the union doesn't abide by the injunction, well, you know, they can be fined, put in contempt of court, fined, subject to sequestration, and all the rest of it. Whereas, as you rightly say, the P&O case, the unions and the workers have got no remedies at all. I mean, they can sue in the employment tribunal, but if they can't beat the offer that the employers made of compensation, there's nothing they can do about it. No injunction is available. So it's a lopsided legal system.
Do you think then that, I mean, one solution would be to say in these cases that if the employer doesn't comply with these legal obligations, then it should be possible for the union or workers' reps to obtain an injunction to stop the decision from being implemented until the obligation has been complied with and agreement has been reached.
Well,
and during that time, not only can the decision not be implemented, but wages will continue to be paid until such time as an agreement has been reached for the workers in question.
Well, that's the central proposal that we put into the bill, which we drafted for Barry Gardner, which fell, but is now being pursued by Lord Tony Woodley in the House of Lords. I think it's the only sort of workable way of moving towards redressing the balance. It doesn't do it completely,
but then what you also do, you also deal with unfair dismissal. So during this period, you cannot be dismissed because you have refused to accept what is in effect a unilaterally imposed pay cut.